Well, the U.S. Court of Appeals, they have upheld a portion of the Minnesota Producer Protection Act, holding a parent company liable for the cancellation of more than $6 million worth of chicken production contracts. Well, Roger McEowen with the Washburn School of Law joins us now to recap the situation in today's Rural Money segment. Roger, as always, thank you very much for your time here this morning. So diving on into this matter, give us just a bit of background on it, if you would.
Yeah, this is a really important decision that came down last Thursday by the Eighth Circuit Court of Appeals, sitting up in Minneapolis. And what this is a law that Minnesota adopted as a result of the farm crisis of the 1980s, and they passed it, and the governor signed it into law back in 1990. And what it did was purport to hold a parent corporation responsible for contract breaches by a subsidiary. And what happened was that the subsidiary company, a processor in this instance that had these contracts with numerous growers in Minnesota, filed bankruptcy and notified the farmers that in the coming 3 months, we're going to terminate all your contracts. So leaving the farmers essentially holding the bag, so to speak. And of course, the farmers couldn't sue the bankrupt company, so they went after the parent, citing this 1990 law. Lost in the trial court, but the Eighth Circuit reversed unanimously last week and said that law does apply to this parent company, and they are responsible for the over $6 million of payments that are owed those growers.
In summary, Roger, what would you say was the big issue at hand here in this matter?
Well, the big issue, I think the take home for farmers and ranchers and legislatures across the country, and particularly in the Midwest and the Great Plains, is that these laws coming out of the last farm crisis, and this one in particular, was designed, and the legislature had given us a great public policy statement. And the purpose of this was we want to provide financial and legal protection and additional safety net for farmers that can suffer abuses under these contracts. And the court upheld this, said, yes, it does apply. It does apply to an out-of-state corporation that is doing business in this state. And so it does provide some protection for those growers. And that's the lesson, I think, that if other states want this type of legislation, particularly in the contract states, contract-heavy states such as Iowa, Missouri, this is a case they want to look at to see how the Minnesota legislature wrote this law.
All right, Roger, as always, thank you very much for your insight this morning. Go online to washburnlaw.edu for more information. Roger McEowen out of Topeka connecting with us today. As always, Roger, thank you very much for your time.